Just to the Judiciary Committee meeting, right?
Yeah. We're about to get started. The members of the committee, on the agenda sheet, you'll see by each bill, there's a couple bills that's been carried over. HB 28 is being carried over by at the call of the chair, and then also HB 118 is being carried over by the sponsor, and the public hearing has been removed. Now, there was a number to the left. Your packet is assembled in the order that the numbers are identified: 1, 2, 3, 4, 5, 6, and 7. So it'll be in the order of those numbers. The first bill on the calendar is HB 64. Mr. Bolton. And I'll mention this. Judge Hill is the chairman of the committee, and he is in another meeting. And when he gets here, he'll preside. But Mr. Bolton, you'll explain your bill.
Yes, sir. Thank you, Mr. Chairman. HB 64 is an addition to Section 13A1172 for certain persons prohibited to possess a firearm in the state. And what this bill seeks to do is simply to add the provision for persons that are in the country illegally, except for the exceptions that are provided in the federal code. Now, this is already a felony offense under the federal jurisdiction, and what this does is simply brings the same standards under the state jurisdiction to allow those to be handled through state court, and rather than having to go through federal court.
Okay. Does anybody have any questions? Any members of the committee have any questions of the sponsor? Yes, Mr. England, Representative England.
My fellow delegation member, is this
Yes,
like
sir.
Is this your first bill in front of
This is it.
you?
Roll Tide.
Roll Tide. Yeah, you. And again, I did a little research on it. This is you said already, this is a federal prohibition already, right?
Yes, sir. That's correct.
Okay. Now, just a few questions.
Sure.
As a state law enforcement officer, how would you enforce this particular code section if it were to pass? How would you do it?
If it were passed, what you would do is once you investigated and determined that there was not legal standing for the person to be in the country, which I did not specify an investigation procedure to do that in the bill because there are many different ways that can be done, and you come to the determination that the person is in the country illegally, then you can proceed with the prosecution.
So this would be one you'd have to get a warrant first.
Yes, sir. Yes, sir. Unless you produced some type of evidence on the scene by the person either saying they're in the country illegally or some other evidence, but it would appear from the normal investigative procedure that would be a warrant case.
Yeah, and a person merely telling you that they're here.
Yeah, it's not necessarily good. You got to have verification. That would give you a good PC to carry further.
Yeah, I mean, it could. That's close. But I do want to point out, though.
Sure.
Do you know what would make this a lot easier to do?
What's that?
Requiring permits.
That bridge had already been crossed. So.
Yeah, I mean.
Thank you though for your input, though.
Yeah, but I mean, requiring a permit would make it because you wouldn't even have to ask these questions. You would actually say if you got a permit or not, and if you're here illegally, you couldn't get a permit, so you could just. It would cut down on time. It would cut down on safety issues, conversations. You can say, just give me the pistol and put them in custody. Instead, here, you have to let them go. Because even if you had a good information on the scene that this person may be here illegally, you still couldn't make an arrest.
Yeah, not without a whole lot of information.
Yeah,
you could possibly accomplish that within a couple of 3 hours while you're at work on that shift.
You'd have to call the federal government. You'd have to call.
It would depend, yeah.
And determine what their status was. You have to determine if they were here, if they were given asylum. I mean, it's a very deep.
It wouldn't be fair just to be dropping a hammer on somebody without doing appropriate follow-up.
Yeah. And I tell you what, that permitting process would have made this one unnecessary. Anyway, that's all I got.
Anybody else? Any further questions? Do you have a motion for a favorable report? Had a second? Second. Robbins. All in favor to give the bill a favorable report, say aye. All opposed? The bill gets favorable report. Congratulations.
Thank you, Mr. Chairman. Move the committee.
We have SB 44, Senator Singleton. We didn't mean to put another representative in front of you, but we try to give courtesy to the
It's
Senator.
fine, Mr. Chairman. I take it wherever I can land, Mr. Chairman. Thank you for allowing me to come today and put me up on your order, your calendar. This is a simple bill. This is just a bill dealing in a committal proceeding in probate court. Normally right now, as an advocate, an attorney who advocate for a person in probate court, if they do some work prior to being appointed by the probate judge, they cannot get paid for that work. So all this does is allow lawyers to be able to be paid for the work if the probate judge so see fit that they be paid for the work that they did prior to being appointed by the judge. So that's basically as simple as the bill goes, is to be able to give those attorneys those attorney fees for those who had done prior work, but it also has to be approved by the probate judge before they could just submit anything.
Okay. Any member have any questions about this bill? Representative England.
At the appropriate time, make a motion to give the bill a favorable report.
Okay.
Second.
Any other questions? All in favor of giving the bill a favorable report, say aye.
Aye.
All opposed? The bill gets favorable report.
Thank you, Mr. Chairman.
Good to see you.
Thank you.
Yeah. We're on this one in this order here. 3, 4, we're for this one. Yeah, you start with 3. Yeah.
Okay, Representative Treadaway, would you tell us House Bill 153, please?
Didn't understand why you'd move the senator in front of my bill, but I must have some bills upstairs or
Treadaway,
something.
on second thought.
All right, so this bill here is, you sure?
Yes, sir.
All right. What this bill would do, this bill would make it a crime to place an electronic tracking device on the property of another person without the consent. I actually had some of the surrounding cities in Jefferson County actually called me on this bill a year or two ago, and where a young lady was tracked from a nightclub, and they had a hard time getting a warrant. So what this bill does is basically just writes it into law and spells out the penalties. And there is an amendment.
Mr. Chairman, at the appropriate time, I have an amendment.
Please, go ahead.
This is an amendment, I believe, is a friendly amendment by with the sponsor. With respect to line 79 on page 3, it would clarify the definition of owner to include someone who has possession or other interest in the property without the consent, and the defendant has no authority to exert control over that property. And the second portion is with the criminal proceeding being pursuant to this section, the crime shall be considered to have been committed in all the jurisdictions. So it's more of a jurisdiction issue to make sure we don't have any issues with where to bring the charge. And the third portion of the amendment is that the crime shall have been committed in these counties as far as jurisdictions as well.
Are there any questions concerning the amendment?
At the appropriate time, make a motion to adopt the amendment.
And there's a motion to adopt the amendment. Is there a second? Second, thank you. All right, motion second. Any further discussion on the amendment? All in favor, say aye.
Aye.
On your amendment, any opposed? Amendment is adopted. Straight away, you ready to go forward?
Yes, sir.
Anything else we need?
Move for a favorable report.
Make a motion for
Motion for a favorable report. Is there a second?
second.
Motion and a second for a favorable report. Are there any questions concerning this? Then all in favor of favorable report as amended, please say aye.
Aye.
Any opposed?
Thank you, committee.
Thank you, Mr. Treadaway. We appreciate it. Representative Stubbs.
Good afternoon, Chairman Hill and members of the Judiciary Committee. I appreciate the opportunity to present this bill to you today. This is House Bill 183. This bill presents an opportunity for us to add 3 additional circuit judges to the 19th Judicial Circuit for one of those positions, the 23rd Judicial Circuit, and the 28th Judicial Circuit. The 19th represents Autauga, Chilton, and Elmore counties. The 23rd Judicial Circuit comprised of Madison County, and the 28th Baldwin County. As many of you are aware, and I'm certainly not minimizing the fact that we probably have judicial shortages throughout the state of Alabama. These three particular judicial circuits have been overwhelmed for a number of years, including reports from the Supreme Court of Alabama, which indicate the caseloads that they are presented with and the challenges that they have to move through the dockets that they are trying to fulfill for the citizens of Alabama. And so this bill would at least move us in the right direction in terms of providing these three circuits with an additional judge. This would take place upon signing of and passing the legislation. This would take place, the election would take place at the next general election for these three positions.
Okay. Does anyone have, these are, I believe, the top three weighted caseload needs in the state of Alabama. Does anyone have any questions concerning this? Yes, sir. Go ahead, Mr. Ingram.
I don't, that we got a whole process. The judicial reallocation process is also going on where, if I'm not mistaken, these particular judicial circuits have been number one for several years. Then 2 years ago or a year ago, the formula was redone, and then Madison County jumps to the top, and the judgeship is taken from Jefferson County and moved to Madison County. That just happened, last year, I think, or yeah, this happened last year. So then the formula was reapplied, and all of a sudden now, these judicial circuits are back at the top again. So it's a really tortured process. And we've approached it from about 4 or 5 different ways over the last 5 or 6 years. And I don't think, I know the judicial weighted caseload says that y'all have a need, but I guarantee you, if you go to every judicial circuit in the state of Alabama, the needs between each judicial circuit are almost indistinguishable. I could take you to Tuscaloosa County right now, and our judges are overworked, and our community continues to grow. We need more district judges. We need more circuit judges. And, we've introduced legislation in the past, and it never was even allowed to get to this point. And the only reason I say that is because the way we're doing it can't work. It just doesn't work. You go to Jefferson County now, they have one less circuit judge. And the way the process works, they'll have another check. The way the allocation formula comes, in 2 years, if there's a vacancy that qualifies, another judge will be taken, and I think it'll be taken and given to this judicial circuit. Then you got a bill that comes up, and now the point I'm trying to make is this is unsustainable. Judicial circuits are being pitted against each other by the Administrative Office of Courts. Mm-hmm. So if we piecemeal it, then we're further and further away from an actual answer to the problem, because every judicial circuit needs more judges. Mm-hmm.
Well, I certainly appreciate those comments, and I am not disputing at all the need for both district and circuit judges throughout the state of Alabama. I have watched this process from afar as the chairman of the county commission for the last 6 years. I've had numerous conversations with our 19th Judicial Circuit and our district judges, all of whom say the same things that you are reflecting, and I think that those issues are valid throughout the state. However, as I stated, I've watched the process for 6 years from afar, and as you stated, we're not moving anywhere, but we can either continue to not move anywhere, or we can start making progress towards this, because the only people suffering are the people of Alabama who are find themselves waiting 6, 12, 18 months for their cases to move forward because of that. And so for me, we should be doing all that we can to help as many people as we can with the resources we have available to us. This bill offers that opportunity for the 3 judicial circuits that have been for several years identified as those who are facing the most substantial backlog. That, again, is not to dispute the backlog that has faced throughout the state, and I hope and will do all that I can moving forward to try to remedy some of the issues in other parts of the state and other circuits. Absolutely.
Well, and I'll let it go, but for every judgeship, I think the law also requires 2 district attorneys, too. I think it's required. Isn't that right? Because I think for every judgeship you create, I believe the law requires you to also.
I think it requires some. I really did not know the number.
I think it's. I think it's 2 per judge. I don't know who's going to pay for those folks. Also, the resources that you have available to you countywide. I don't know. This is the state of Alabama problem where we need judges. I just don't think it's the best way to approach it that forces you in a position to come up with legislation to piecemeal a problem that the entire state has. So, I would much rather, and I'm not, obviously we're frustrated in Tuscaloosa County because we've been asking for this for over a decade now. And the problem just continues to get worse. To that end, Judge Hill has sponsored bills to bring back retired judges to try to deal with some of this backlog. But I want to, at some point, as a body, maybe we ought to force ourselves to create a comprehensive solution where we create judges, because we got the money, obviously, and we're paying for water parks. So why don't we try to force a comprehensive answer to the question where we create judgeships across the board for all of these judicial circuits that need judges? I hate that you're even in this position where you have to sponsor legislation because all of us know we all have the same problem, and now our constituents are going to say, "Well, why aren't you doing the same thing?" So anyway, that's all I have.
It's fine. Let me try to answer your question a little bit, okay, Mr. England? I've sponsored House Bill 145, which is now pending in the Ways and Means Committee, and that House bill calls for the creation of 13 judges, and it does it over a staggered period of time. I agree with what you're saying, that we need to look at this state as a whole, and Tuscaloosa is in that group, by the way. So see there, you go back and tell your folks that your persistence has paid off, assuming we can get it passed. But you're right. Here's though, the truth is, even if you get a favorable report, this is going to go to Ways and Means, and it does need to be factored in with the overall overarching situation that we have in this state.
And sir, if this bill moves to the Ways and Means Committee and your bill also moves and your bill receives a favorable report and my bill does not, then I will fully support your bill. It actually expands what I'm trying to do, but I also recognize and have constituents that I am here to represent and serve, and I'm doing all that I can to alleviate some of the pressures on our judicial circuits throughout the state.
And you got a problem. We know that. We know that. And nobody's making light of that, really. Nobody. Are there any other questions for this gentleman? I will entertain a motion for a favorable report.
Make a motion for a favorable report.
Is there a second? Thank you. Any more discussion? All in favor, please say aye.
Aye.
Any opposed? Okay, you get a favorable report.
Thank you.
Again, it's got to go to Ways and Means.
Yes, sir.
Okay.
Thank you. Appreciate it.
House Bill 131, Representative Kitchens.
Thank you, Mr. Chairman, members of the committee. I wanted to bring this House bill to you. Y'all may be familiar with the Jimmy Spencer case, and through that, there was a loophole in the law. What this bill does is it helps close that loophole up. So it just simply states that if you have charges while you're in prison brought against you that is punishable by more than 6 months sentence, you cannot be up for parole. So he was actually up for parole while he was awaiting his charges for 3 capital murder offenses. I'd be happy to answer any questions. There's only the one section that this bill changed from current code.
Any questions for Representative Kitchens? And I will entertain a motion. Go. We have a motion and a second for a favorable report. Seeing no further questions, all in favor, please say aye. Aye. Any opposed? Thank you, Mr. Kitchens.
Thank you, Mr. Chairman and committee.
I believe you're next.
A second. Give me the door. It's the door. So it's just down to mine and the, okay, then let me do this.
Good after this, we'll get you a cookie. Just had 2. Thought you were coming to get on.
Chairman Hill, I believe you got HB 144. If you could explain it, please.
Sure. Ladies and gentlemen, from time to time, we use interpreters in our court system. What this does is it gives the opportunity for an interpreter to become certified. There is a fee for becoming certified. I grabbed the wrong piece of paper, but it's somewhere in the neighborhood of $900 to take the test. And then at that, it's a one-time situation where the individual is a interpreter in our court system. It's something that AOC asked me to do. It makes sense to me that we should certify these folks to the best of our ability.
Does anyone have any questions?
I move for a favorable report.
Do I have a second? All in favor, give the bill a favorable report, say aye. All opposed, bill gives a favorable report. Thank you.
Thank you.
Move for a new chair. Jim. We switch over here. That's what England said. Get anywhere.
Okay, ladies and gentlemen, the next thing that we have, it's going to be House Bill 190. House Bill 190 is sponsored by Representative Wadsworth. There's a public hearing today. Do we have, Brandy, you got me a list of who's going to speak? Okay. We have several people who have asked to speak. I'm going to ask you to hold your time to 3 minutes each. We will not vote today. We will not vote today. We will let you all listen to the public comments, and then we will take and vote. We will vote this at another time. But go ahead. Why don't you, Representative Wadsworth, explain the bill that you are proposing?
Okay. Thank you, Mr. Chairman and committee. This bill is an ALI bill that has been designed to help solve a problem in the state of Alabama that's recently come up as a result of a case called Rio Prop Holdings versus Compass. In Alabama, and this deals with tax sales of property when people don't pay their property tax. There's basically 2 methods to sell property for property taxes. One is to go through what's called a tax lien method. There's 41 counties that have it. And then there's roughly about 20-something counties that sell the property at the courthouse steps. The normal process you go through when you do a sale at the courthouse steps is that for the first 3 years, people pay property taxes when somebody hadn't paid a property tax. And then you can do what's called an administrative redemption by going into the probate judge's office and just paying the taxes and whatever fees are there and redeem your property. But after 3 years, the property, a tax deed is then given to somebody who has purchased that property. And the normal process prior to this real post case was that they had what they call, the original owner had what's called a judicial redemption. And there's several methods of doing in time periods involved. Typically, most people leave this like 3 years to redeem the property after a tax deed is given. However, if it's unimproved property that nobody has moved on to, then you can have up to 10 years. And then if there is property that the landowner is still on that property, that it tolls the time period and they have really an unlimited right in period of time to redeem the property. And then, but at this point, once that tax sale occurs, the person who purchases it owns that property. Now, this case that came out basically said that after 3 years, if you don't file a petition to quiet title through the court on that property, then that real estate that they paid those taxes on in a tax sale, that real estate reverts back to the original owner. And I think I'm saying this correct. You don't have to pay the taxes that they paid. They don't have to. The original landowner doesn't have to pay it. What this bill is designed to do is to put yourself in a situation where you can get clear title to properties. This bill was put together by a group, and like I said, it's an ALI bill, so that there is like a 6-year statute of limitations where somebody can go in and file a petition to quiet title and to redeem that property. And then they can go in within that 6-year period and redeem it. If they don't redeem it within the 6 years, they lose that right to redeem it. If you have a homeowner that is actually still living on that property, that 6-year time period is stayed, and so that they can do it a longer period of time if they're living on it. But the purpose of this bill is to put together a set of time frames and statute of limitations that are designed to clarify when a piece of property is clear of title and has a clean title. And I'll give you an example. I do title work, and I was given a tax deed the other day, and they wanted me to do a title. I can't do one because I can't give anybody clean title on a piece of property because that is a tax deed. The law is just murky as everything, and this puts clarity in the situation. Now, some folks want to move more toward the tax lien method. Well, if you do the tax lien method, what happens is the only people who can redeem it is if you sign up on a computer and get you a bid list, and then you buy it on the computer. You got a lot of folks in rural areas that don't have internet, don't know how to operate a computer, and they prefer the tax sale method where it's sold at the courthouse steps, where they can go and do it there. But that is basically what this case is about, is to bring clarity to this tax sale issue and to get clean titles on pieces of property. Otherwise, there's not a problem until there's a problem, basically what it comes down to.
Thank you. Ladies and gentlemen, we have several people who wish to go ahead.
And let me mention, I do have an amendment that is more of a clarification amendment. Do you want me to do that now?
Sure.
Or okay. There's the amendment deals on like page 120, on page 5, line 126. That line, and then with the line below D, notwithstanding subsections A or C, comma, if. And then on page 151, replace that line with F, notwithstanding limitation period provided in. And then replace line 163 on page 6 with the following G, bracket G, close bracket, bracket 1, close bracket, notwithstanding the limitation period provided in. It's more of a clarification, but that would be the amendment. Can I offer that amendment?
Okay, yes, you may.
I second it or move to adopt it.
Let's all right, there's a motion to amend and a second to adopt. Is there any discussion on the amendment? Okay, seeing none, all in favor of the amendment, please say aye.
Aye.
Any opposed? Okay, your bill is amended. Thank you, sir. We're not going to offer it today. However, we do have some folks who want to speak in favor and some in opposition. And let's start, I guess, Mr. Luker, are you here? Mr. Luker, you're asked to speak in opposition to this. I'd ask that you please hold your comments to about 3 minutes.
Okay. Mr. Chairman and distinguished committee members, my name is Charles Luker. I'm a retired Revenue Commissioner for 34 years, and I've worked with the Alabama Association of Tax Administrators 8 years. I've dealt with property tax sales for over 40 years. There are two officials with me, Mr. Don Armstrong, Property Tax Commissioner from Shelby County, Mr. Kenneth Crow from St. Clair County. The synopsis of House Bill 190 identifies as one of the purposes of the bill is elimination of the time limit established by the Rio Prop Holding LLC case, within which a tax purchaser must acquire possession of the property or file suit for possession or face forfeiture of the tax title and tax lien. However, the bill goes much further than that. It establishes an entirely new statute of limitations and procedure for redeeming from a tax sale and challenging the validity of the sale with removing the time limitation. That's all in favor of the tax sale purchaser. The Association of Alabama Tax Administrators is concerned that this new procedure will benefit tax sale purchasers at the expense of the property owners and others with an interest in the property. Is not in the best interest of the citizens of Alabama. Neither the AATA nor the ACCA was considered in the development of House Bill 190. We have 4 significant differences and objections. The current system for redeeming these tax sales and perfecting title to the property for over a century. The law has evolved over the period of time through court decision rather than legislature. Of course, in recent times, there's been a spate of amendments offered to address the troublesome areas of the tax sale. But the best remedy we have for a tax sale was a tax lien sale that the legislature passed in 2018. In a tax sale auction, we sell the tax lien and not the property. And many of the tax sale problems that have risen are avoided in the tax lien sale. Since 2018, 44 counties have switched to the tax lien sale, and more expected to do so in the next few years. ATA does not believe the complete overhaul of the land sale procedure, a method that is on its way out, we hope, is called for. It would cause confusion, conflict, and for that reason, the ATA opposes House Bill 190. The current system, is Mr. Wadsworth pretty well explained, the current system for redemption, both statutory and case law, while not perfect, is at least familiar with the tax officials and the judges and attorneys who have to handle these cases in court. Some critics characterize it as complicated. I don't know where they get that. However, the new changes proposed in 1980 is more complicated. It's full of exceptions, cross-references, and conflicts. As Mr. Wadsworth said, the redemption of tax sale generally is 6 years. The first 3 years is a statutory redemption, and then the second 3 years is referred to as a judicial redemption, as it requires an action filed by the redeeming party in court. The second 3-year period also applies to actions for possession of the property, even those actions by the tax sale purchaser. The second 3-year period is contained in Title 40-1082. That's the part that's been amended. The right to judicial redemption and the procedure to be used to enforce the right is provided for in 40-1083. And the appellate court decision interpreting and applying this section, 40-1082 and 40-1083 creates two procedures, judicial procedures for redemption of property, which would be a conflict. Historically, Alabama courts have protected owners from losing property by requiring strict compliance with the tax sale statutes and placing the burden upon the tax sale purchaser to approve adverse possession of the property for the 3-year judicial redemption in Title 40-1082. Unless the tax sale purchaser could prove adverse possession limits the owner's right and not the tax sale purchaser. House Bill 190 reverses this arrangement and favors the tax sale purchaser. Remember that a tax collection official's responsibility is to collect delinquent property taxes. Tax sales are not intended to provide an easy method for a tax sale purchaser to acquire property at a fraction of its value. Instead, a tax sale is a method to coerce a taxpayer to pay their property tax in fear of eventually losing their property tax.
We appreciate it, Mr. Good job. Thank you.
One more point. The real prop case held that because a tax sale purchaser had neither gone into possession nor filed suit for possession within the 3-year limitation for the period in Title 40-1082, title to the property reverted to the owner without necessity of the owner paying anything to redeem the property.
Thank you, sir. Appreciate it. Kimberly, you want to speak in favor?
No.
Good afternoon. All right, the thing about this bill that Representative Wadsworth explained well about what it did, it may be helpful to explain what it doesn't do. It doesn't change the statutory redemption period. It does deal with the issue of possession, which right now is virtually unlimited because it's defined in the statute as constructive and scrambling. And of course, the presumptions are if in a situation where the state has taken over the property, the presumption is the owner remains in possession, and in some situations where there's been a purchase, if nobody's in possession, then it assumes that the owner is in possession. So what you've got is a situation where there is no time limit on a period to redeem. This would preserve the person who is in actual possession of the property an unlimited period of time to redeem, but it puts a 6-year period on absentee owners. In other words, they've got to take care of their business because there's virtually no way to move that from inventory on the tax rolls back into use unless there's some certainty as to when the tax sale purchaser can move on that property, which it still preserves, of course, the original 3-year period for anybody to redeem. So it allows everyone to get a ruling on those issues in court on any issue regarding quiet title and gives some certainty to the tax sale purchaser, and also preserves the investment of the tax sale purchaser, as Representative Wadsworth mentioned, by keeping that lien of the tax sale purchaser So they do not lose their investment after paying the taxes and basically losing their entire investment if there's not a redemption that takes place in that period of time. So transitional issues, my last point. There's this argument that everybody's transitioning, counties are transitioning to the tax lien auction, which is fine. There's a 42, 40, some 43, some counties that are going that way, up from 10 from about 4 years ago. So it's moving that way, but there are huge inventories of properties still that were sold under this tax sale statute. 25,000 plus, I think, is probably a conservative figure. And also a good number of counties, more than 24 counties, are still using tax sale. And even the counties that transitioned into tax lien auction still have a large inventory of tax sale properties before they transitioned. So this is just a way to give some certainty to the tax sale purchaser, to the county, to the state, to get these, to have a way to get these properties that are not in possession by the owner, to move them into use again, rather than being on the rolls of the government as a tax sale, unredeemed tax sale. Thank you.
Any questions for Mr. Kimberly?
Mr. Chairman, I have
Yes, ma'am, please.
question. Mr. Kimberly, this is Alabama Law Institute bill, is that correct?
That's correct.
And can you explain to the committee who all was on the committee that proposed this bill?
Well, it's the Standing Real Estate Committee is a body of practitioner real estate attorneys. And I can get the list of the members I'll leave some folks off. It's about a dozen practitioners from Huntsville all the way to Baldwin County that responded to a request by a couple of senators on the Senate Judiciary Committee last year to do something about the RIA-PROT ruling, which they considered unjust. So this is our response, and in the meantime, deal with these all these properties that are currently in inventory as a way to try to move towards getting those properties back into use.
Thank you.
Yeah, go ahead.
I'll get a list of the committee members to everybody on the judiciary.
I mean, so others may care for that. I just was trying to get a general idea of, in general, who was on the committee so we could understand.
It wasn't put together for the purposes of this statute, if that helps answer your question. It's a standing committee that responds to various real estate needs and is always working on some issue in the code or another.
Okay. Mr. Robbins.
Hey, Judge, I have a few questions. How are you today?
Yeah, good. How are you?
So basically the facts that you just gave, I know that there's the 25,000 you said that are being held by the state. Those are only that are 5 years or older. So those that are 1, 2, or 3, it's even more than that. So you're talking conservatively 25,000 for 5 years or older, less. So you're talking thousands and thousands and thousands that we're going to have to get off our tax rolls.
Yes, sir.
And what you said also, in Talladega County alone, we have 468 tax parcels. So even small counties are inundated, even though we've moved to the lien system in Talladega County. But I just had a couple questions. So one question that I had, why did y'all add, or what was the motive in saying that a person, when a person brings an action, that they must pay into the court the redemption amount minus the excess bid? But, the reason I asked that question is the whole point of the tax process and everything is all about equity. So if I am the redeeming part, or if I am the party that has filed a counterclaim to redeem the property, I pay into court, my money gains no interest while this case could sit and linger for a year to 2 years, while the tax sale owner is gaining interest every month. And so I just kind of wondered, why not just wait until the final end and let the judge make a ruling that your redemption amount is X, you have the 90 days to redeem it. So I just kind of wondered why we did it that way.
I think it was due to just making sure if you're ready to make that move, you've shown you've got skin in the game, you're going to follow through rather than go through an empty procedure of not following through at the end with your intentions of redeeming or paying whatever the lien is, depending on how the judge rules as to who would end up needing to make that payment.
Okay.
David, I was wondering, I remember this bill being presented in ALI meeting. I do not practice this type of law, and I certainly understand the need to get these properties out of the inventory. The government, are having these held. And is that the big, I heard you mention that a couple of times. So could you just briefly address that for me? What is the big need with moving these properties? Because you said that a couple of times about trying to get them off the rolls, or.
Well, obviously, tax sale purchasers look to invest in property for a particular reason, to use that property at the appropriate time after the statutory periods and the judicial periods are over, and purchase it for typically for a reason, sometimes other than just investment, but the intention to sell the property and use it or use it in some form or fashion. And given the fact that we have a statute now that says that its possession is unlimited, it's unlimited to redeem if the possession is constructive or scrambling. Anytime the tax sale purchaser moves to ask for a deed from the on the property, the owner simply has to say, "I'm still in my redemption period," and there was nothing in the statute that made that owner move towards taking care of that issue. This bill says that the court has you can file an action and get, if you notice the statute says you can get a ruling on all these issues from the court at the appropriate time. And so it just gives some definitiveness to, allows everybody to have more, the community to have more certainty as to when these properties will be able to be used again, rather than just an absentee owner, perhaps in another state, just letting it lie for as long as they want, and then simply responding when there's action taken, "I'm still in my redemption period," and the court having to say, given the definition of constructive and scrambling and the presumptions that are made by the law as to what possession means, just has to say, well, they're right, and nothing else happens.
So can you would what Mr. Luker was talking about earlier, his concerns on the bill, and I have a handout from them. Can you address any of his concerns that he raised?
Could you be?
Well, I did. He did a very good job of presenting a lot of material, but I didn't know if there was anything you heard that he said that you could respond to.
Well, I heard him say it puts a lot of puts a lot more rules. We're familiar with this. We're comfortable with this system. It may be, but it doesn't help anybody move the ball. So I would respond to that because we're comfortable with the system doesn't mean that it certainly couldn't be improved. We're all moving. I heard him say we're all moving to the lien system, lien auction system. So why are we doing this? Well, I think I indicated that the reason is we've got a whole lot of property and still a good number of counties that are still using the tax sale, and the ones that haven't moved to the ones that have moved to tax lien auction still have a good number of inventory. So those would be my responses. That's two main points I heard him make. It's really just it's really more of a, even if we're phasing out, it's really a way to have a better game plan on how to phase out and not just leave it open-ended, as I think this whole statute will. even if we are moving into a new system.
Mr. Standard, you got a question for Mr. Kimberly?
Yes. I do understand that the, from my experience as probate judge and being a local official, that can be a confusing process and, and all that. My question though would be, in putting this legislation together to try to address those things, did I understand right that there was really, it didn't have any input from the local tax officials or revenue commissioners on the, what would go in the bill? Because I know locally we depended on them, locally to carry that out, to carry out what needed to be done. And so it just seems like their input would be important.
Well, thank you, Representative Standards. It certainly wasn't it wasn't an intentional oversight. It was just the committee saw, and right or wrong, saw this as a neutral issue with regards to the tax officials. We didn't see any. It seemed to affect the owners, tax sale purchasers, mortgage holders, lien holders, other lien holders. IRS, things like that, more than it did the officials who basically are essentially waiting on somebody to come along and redeem the property or file a quiet title action so they know who to give a deed to. And if, so it wasn't an intentional oversight. It was just that we didn't see that they, like, we were obviously wrong, but we thought we didn't see how they would be upset by this way to move the ball down the field a little bit as we saw it.
I understand. I mean, I don't think there was an intentional issue. I just, my thought though is they could add some value. They could add a lot of value just based on their experience and what they have to do every day on it. So,
yes, sir.
Mr. Robbins, did you have another question?
I did. I think you should just reiterate, Judge, that based upon real prop, if a tax sale owner does not file an action, that property reverts back to the original owner. If correct, if a party takes no action to quiet the title, it would revert back to the original owner.
Yes, Representative Robbins, this wasn't it wasn't the fault of the appellate court, the real prop. It was a decision they were forced into by the way the statute was written, in a way that just didn't provide for several issues. One of them being a way to maintain your lien after the 3-year judiciary period is up, even though you paid the taxes on the property every year.
Right.
So it was just a hole in the statute that we're trying to fix, which may explain a little bit why we went into more detail than just fixing the real prop issue, but trying to put some meat on the bone on this statute to have a good workable plan for both owners and for tax sale purchasers to have a plan going forward after the statutory period is up.
Right. Like, for instance, if you were a tax deed purchaser and you're not astute to the law, you would not know you needed to do that, and you could have spent thousands in taxes and just lost the property because the party would be able to file a redemption and redeem the property without ever paying $1 in taxes for 10 years and then just get the property back simply because you failed to file an action because you're not a lawyer. And then I guess my next question, or something that I feel like should be pointed out, is that as long as you are still maintaining some form of possession of the property, you can redeem at any time according to the new law, right? And the way the system is now, most title companies will require a person to file 2 actions. So they won't insure it unless you file the ejectment and then you file the bill to quiet title. So the way the system is now, you're putting the onus on the tax deed purchaser to not only file a bill to quiet title, but to file 2 court actions, an ejectment, because without that, the title company will say, we don't know that you've actually possessed the property, even though a judge says that you have clear title of the property. We need to see your ejectment action. So another problem that's occurred because of the rear prop is that people are having to file 2 actions, and you have to file that possession almost immediately. And if you don't do that, some title companies will never insure you, or your statute starts going even further. So this will eliminate that process of 2 actions that a person has to file.
Yes, sir. It does that. You're correct. Also, it still doesn't require the owner to do any more than file the redemption. It doesn't require the owner to engage in a lawsuit. The owner still has the option of just redeeming the property. So yeah, it accomplishes what you're talking about. It makes that. I think it defines the process that the judge can make all those decisions in one time with one action, and then also still maintains the right of the property owner just as simply to redeem within the appropriate time frame.
Mr. Faulkner, you had something else?
Thank you, Mr. Chairman. I know you frown on doubling up, so I'm going to be very brief. I have just one question. So, Judge, we've got a list here of the tax lien sale counties. So 43 of 67 counties have converted to this new method. And does this bill affect any of the new counties, or is it entirely going to the old ones that are have still not converted?
It applies to the new counties that have inventories of property under the old tax sale system. So it'll apply in those counties. If your property was sold in tax sale, then the revised statute it will be the one you use. And of course, this doesn't require you to use the statute. If your property was sold, of course, as you know, or was dealt with in the tax lien auction, obviously you wouldn't use the statute. You'd use the tax lien auction statute. So it doesn't require anybody to use it. It only if it's applicable to your particular real estate. Yeah.
Thank you, sir. Okay, Mr. Walker, you wanted to speak in opposition to this?
All right, thank y'all.
You're welcome.
Thank you, Mr. Chairman and members of the committee. I'm Jeremy Walker, Chief Executive Officer of the Alabama Association of Realtors. Grateful to be here today. We speak in opposition to House Bill 190. We represent 19,000 realtors across the state. Many times we're the only voice for the homeowner, and we also represent investors. We have a number of members, so we're kind of on both sides of this issue. The tax sale redemption issue has been a problem for a long, long time. There are no easy solutions to it. We have a lot of respect for the Alabama Law Institute and the work that this committee put in to this issue. As we heard from Mr. Kimberly, it was the existing real estate group. We have a perspective that it may be a little heavy towards the investor side, because we've heard a lot of talk today about protecting the investor. I don't think I've heard anyone talk about the homeowner in here or the landowner who has an underlying right in this when we change the process. And so for that and many other reasons, we speak against this bill. We think it does some good things, but we need a holistic solution. You guys do have a map in front of you of 43 counties. You guys know the way government works. Government is slow. When you get 43 counties to jump on to a new system and a new way of doing business in 5 years, I mean, that is warp speed. I mean, so when we hear from Mr. Luker and the groups that he represents, who we have a lot of respect for, these are the people who don't have a stake in this. They're there to represent the government's interest. We have a public interest in being sure that people pay their property taxes on time. That's how we fund government. And that if they don't pay their taxes, that they have a fair process for the homeowner, which the homeowner has clear notice of how the process will work and how they can redeem their land. If somebody doesn't pay a $1,000 property tax bill, they're going to lose their home, their farm. Many of these properties are not desirable, but there are some that are. These investor groups, many of them are good, but there are some that are highly predatory, that come in and they jump on a piece of property and they overbid it. Overbid means you owe, let's say you owe $1,000 and you fell behind. An investor group comes in and says, that's a piece of land that we want. And they overbid it $100,000 and they up the game. It's really an unfair system, the current system that we have in these 24 counties and some of the properties that exist prior to the tax lien process. So respectfully, again, we would oppose the bill. There's also an issue pending before the United States Supreme Court dealing with homeowner, landowner equity in these cases. It's a case from Minnesota where if a city comes in and acquires a property or an investor, they're not returning any equity in the property to the homeowner. So for example, you bid, $5,000, you get this land. Well, the homeowner's got $100,000 equity in it. And there's a pretty strong argument that once this is sold and it moves forward, the equity that the homeowner has in the land should be returned to them. So a lot of issues here that have not been resolved respectfully, but we speak against the bill, Mr. Chairman. Thank you.
Any questions for Mr. Walker?
I'm sorry, Judge. I got a question.
By all means. Go ahead.
Hey, Jeremy, how are you?
Great.
So I've got a couple questions based off what you said. First question is, if the tax lien system is so great, why don't we just force everybody in the state to move to the tax lien system?
We would be in favor of that. It is the lesser of the two evils. We would take the position that the new tax lien process that the tax assessors came up with 5 years ago is the most clear, transparent system forward for all counties in the state. And that would get all the counties on the same page and would leave us to deal with the backlog properties. And if I could add, there was one point that was made earlier. I think there may have been a little bit of confusion of two issues. Tax rolls. At current, there are over 40,000, maybe 50 by this time, properties owned by the state on these state tax rolls. Those are already owned by the state. And I think what the bill is dealing with are different investors who are private citizens. It might be me as a private citizen who's acquired one of these properties. So I wanted to try and clear that up because it came up earlier.
And just so you're clear, so we're clear, you said no mention of the owner of the property, but the bill still provides the retained, even constructive possession. We're still making the bill still makes sure that a owner of property that's maintained any form of possession as the owner still has, paid an electricity bill there, has put up a fence there, is using it. They're still constructively in possession of the property, and their right to redeem would never be cut off, correct?
In theory, yes. What I would say is many of your investor groups have representation. Many of these people that are being, foreclosed on, for lack of a better word, or redeemed, they may not have access to an attorney. They may get scared. They may run off. I mean, you want to be sure that you have a fair process, that everybody knows what the rules are, so that these homeowners or landowners know what the rules are. So if they want to stay on the land and try and redeem, they have that opportunity to do so.
I think we all got some questions, Mr. Walker, but let's let everybody else speak. And I think we're not going to vote on this today. Give us an opportunity to further these discussions in the not too distant future.
Thank you, Mr. Chairman, members of the committee.
Mr. Braswell, you got anything to add? Please.
I will break with my usual tradition. I will only take 3 minutes, I promise. To clarify a couple of things, I don't think Mr. Luker said at all that he was comfortable with the current tax sale process. I assure you, no one at the county government level who's involved in this process in any way is comfortable with it in any way. The investor discussion that's occurred, to make things clear for those of you who aren't familiar with that process, Alabama law guarantees the persons who purchase these properties at the tax sale, it guarantees them 8% interest on the overbid, on the interest, and on the unpaid taxes. That's why Mr. Luker and Don Armstrong, who's the revenue commissioner in Shelby County, went to Phoenix, Arizona to look at the tax lien process there to find a way that would be fairer to both the taxpayers and to the agencies like the county commission that receive ad valorem tax. We need to find a fairer way. This bill flips a number of issues, and I would encourage the committee to be very, very careful in moving forward. Alabama law today guarantees an 8% return if you go to a tax sale and buy one of these properties, and I think every one of us would be happy to get a guaranteed 8% return. Who pays that? The person who stays in that house. If they ever try to redeem their property, they pay that 8% back. That's why there comes a point, if we continue to follow the tax sales law, that many people are living in the house but have no way to ever redeem the unpaid taxes. We were not involved in the bill. We would like to be involved going forward, Mr. Chairman, and I will return my 30 seconds to you.
Thank you, Mr. President. I appreciate that. We may try to get this on the
Mr.
record.
Chairman.
Go ahead, Mr. Potter.
Yeah, Mr. President. So you brought up I thought it was really not addressed in this bill, and this is not my area of law. So some of my questions are.
My lawyer's here. She's going to be next.
Yeah, I'm pretty ignorant on this subject. But one thing that has always bothered me is this overbid situation and people making a bunch of money on it.
Yes, sir.
Now, I think we reduced that. We did.
You did. You reduced it from 12% to 8.
12 to 8.
Yes, sir.
On the overbid. But just so everybody understand me, and some of y'all probably do this, but I mean, so somebody owes, you have a $100,000 piece of property and they come in and they pay $300,000. The overbid is $200 if the property was $100, right? I mean, in that
there is a limit on the overbid, and I don't remember off the top of my head what that is. But you may bid over the value, and you get interest on it.
Yeah, and it's always bothered me that you bid over the value. And I always said, well, the county's got to get the money in, and we want there to be paying for money to support government. But it always has bothered me that you got. I don't have a problem if somebody pays the amount of tax that, in not talking about the overbid, you make a % on that.
That's right.
A good, whatever you did, you stepped in, paid the money up front. You ought to be able to make that a percentage on that. Otherwise, nobody's going to do it.
That's right.
But the overbid on people really gets to me, and it always has since I've been down here. That you could charge that much more and still make a percentage on that.
That's right.
And
interest on the interest.
Yeah.
That's the
way. But I didn't think this bill, as I understood it, dealt with that. It's something I would like to deal with, but I didn't think this bill, the ALI bill, dealt with that.
Mr. Chairman. It does not change the interest in any way. I think that Ms. Frawley, who comes after me, will explain to you. We think that the changes tilt toward the overbidder and not toward the landowner. The changes that are proposed, which is why we are concerned that the changes will make it even more difficult, causing the interest to continue to run. We've got to unwind this process at some point. If you passed a bill today and moved everyone to the tax lien process, which we would support, by the way, we still have years and years of property that has to unwind while interest continues to run. And we appreciate your support. You've helped us on a couple of bills to try to address these issues. Mr. Chairman.
Mr. Chairman, I just would like that on the record that the chairman of the civil subdivision has expressed an interest and would like to deal with that when you consider this in the future.
Oh, yes, sir. I've got you. In fact, I just picked that up. Ms. Frawley?
Thank you all. My name is Jamie Frawley. I am a partner at Webb McNeil Walker. It's located here in Montgomery. Our firm represents and defends counties and taxing officials, really the majority of them in the state, in a wide variety of cases, including notably challenges brought to the validity of the bills which would be this one, that they are called to enforce. This bill goes far beyond fixing some of the problems that may have been identified with the RIA Prop Holdings versus Compass Bank. And it's my firm belief that it's really going to cause a lot more problems than it solves. It's going to greatly expand, we believe, the scope and expense of litigation redemption actions. One of the things that concerns me as somebody who represents county taxing officials is the language in the bill that a court shall fully and finally resolve all issues among all parties to the action, including without limitation the validity of sale, and shall enter any of the following orders, including granting relief to respective parties in the event of an invalid tax sale. So what you're doing here is that if an owner or anybody brings something, you know, because all of a sudden you've got to do it all at once, so everybody's going to throw in their complaint, right, that the tax sale was invalid. I mean, I know theoretically the bill doesn't require that, but I think any lawyer who wants to avoid a malpractice action by not raising that is going to throw that in. That's going to drag in automatically the taxing official into every one of these cases and require the taxing official to have to defend the validity of the sale, even in cases where it might not have been otherwise brought up because people were kind of safe in the knowledge of, okay, like I can challenge that later. One of the things that we're very concerned about is that so there was a statement about how this will remove the 6-year period that allows these absentee landowners, you know, to just hold on to their property. We think it goes too far in the other way because it also removes any responsibilities on the tax sale purchasers to do anything with that property. And so what you're going to end up with, we're afraid, is more abandoned and vacant properties, which pose a huge health and safety hazard. They drag down the values of everybody else in the area. They hurt businesses in the area. So we think that goes far. And I will note, not only does it remove any responsibility, unlike these absentee owners, right, that have 6 years, they can let it go forever. Out-of-state investors come in, bid through a proxy, get something, hold it until they decide what to do without time limitations. I want to highlight, and I know that my 3 minutes is up, I will just say this. There are, I think, many, many, many issues that are likely to be litigated, and frankly, as the person litigating them, I can tell you that I think that you're going to lose on several of them. I think that there are serious due process issues. There are serious contradictions between this section with other provisions of the law. Real quickly, I'll just highlight one. I think the most important ones is 4010-2122 right now expressly states that you don't have to pay all of the extra amounts, the amounts for improvements and such, in order to redeem the land. This allows a judge to order that you do and order payment within 90 days, which is a shorter period, so you've got a conflict there. Thank you.
Ma'am, I want you to know we appreciate it. I appreciate everybody because one thing, I think most of us who have dealt with this in the past have found it to be a pretty confusing area of the law. Even if you read the number of appellate level decisions that are there trying to concern this. So we're not going to vote on this today, but what I am going to do with this today is send this to our civil subcommittee, which is Representative Faulkner, Representative Allman, Chestnut, McClammy, Pettis, Robbins, and Stanridge. And several of you have been out there today and said, gee, we would like to work on this with you, and we're going to let you do so. So Representative Faulkner will set a time for a civil subcommittee meeting. We will have said meeting, and hopefully we will come to a resolution. And I would like for us to do this because I agree with you. I have tried to deal with this stuff. It's not easy. It is not easy. But there are a lot of questions that come up. We do have property that's inventoried. What do we do with that? How do you get this either back to the individual from whom it was foreclosed or the tax sale loan, or alternatively, how do you get this property back into productive use? Because one of those two things needs to happen. So let's look at our civil subcommittee and let's see if we can't come up with some of those answers. Ms. Farley, sound like you would be a good person to help with that.
I'll be happy to.
Thank you, ma'am. Appreciate it. And ladies and gentlemen, I think that concludes our Judiciary Committee for today. This is probably one of our shorter ones, but I'm certainly glad y'all all had the opportunity to hear such a fascinating debate on tax sale property. Thank you.